Thank you. We are convening for a public deliberation in the matter of Pikesville Hospitality Investors LLC, Two Farms Inc. developer. Case number is CBA-21 017 concerning the approval of a limited exemption development plan. We had hearings. This case has a long history. It's well documented. I'm not going through it again. At the conclusion of the merits hearing, we invited counsel to submit memoranda presenting their closing argument. It's my understanding that there has been a motion for reconsideration filed by appellant along with or contained within the post-hearing memorandum. And, the question is whether or not to deliberate on that motion now and dispose of it, and then go into deliberation on the merits of the LEDP. And I'm inclined to proceed to rule on the motion for reconsideration now. I'm inclined to deny it, and then I want to proceed with the merits. Do either of you want to be heard in opposition to my suggestion that we can deliberate, but to rule on the motion for reconsideration?
No, I don't. I agree with you.
I agree also, Mr. Chairman.
Okay. All right. So as I understand the motion for reconsideration, which as an initial matter is untimely, it's beyond the board's rules and can and should be disposed of on that basis alone. I understand that it raises a standing issue that Mr. Nelson, again, as I understand it, going on my own recollection, Mr. Nelson raised in some form. Well, I didn't raise it. When we had considerable time for motions in the last hearing, and Mr. Nelson again had raised, and when we once again affirmed that we had already disposed of the issue whether a certain bill was in a legal special law, he indicated that his basis for opposing the LEDP in the merits hearing was going to consist primarily, if not exclusively, on his argument that that bill was an illegal special law. And so when we confirmed that it had already been disposed of in the prior decision back in November, he initially indicated, but we gave him a chance to, an opportunity to gather himself, but he initially indicated that he didn't have any other basis in the merits hearing. All of his exhibits were keyed to the position that bill was an illegal special law. So after we confirmed our decision, he then indicated wanting to have some time to consider stipulations for opposition and so on. And so my point of raising that is, I don't recall him even raising at that point a standing issue. Then we proceeded to the merits hearing, and he's marking by agreement. He is offering exhibits which we mark for identification. Then he moved them in, and I sustained objections to them because they were not relevant. They related to the illegal special law issue. But among them was a 1 of 2 page SDAT printout that purported to show that Pikesville Hospitality Investors LLC was not in good standing. As Mr. Lauer then pointed out, there appeared to be a page 2 that related, if I recall correctly, related to Two Farms Inc. And that was not attached, and Mr. Nelson, at Mr. Lauer's request, indicated he would subsequently provide it. Then there was a letter submitted, and in any event, the board was ultimately given verification that Two Farms Inc. was in good standing. So on the issue of timeliness, firstly, in filing the motion for reconsideration, I think it's untimely, and on that basis alone, it can be denied. I also then just think, as a matter of substance, it doesn't affect the standing of Two Farms Inc. to proceed on this application. It would be my view that Two Farms Inc., who was the applicant for the LEDP, satisfactorily meets that definition. And so, as a substantive matter, which I don't think we need to reach, but if standing can be raised at any time, even on an untimely motion for reconsideration, because the issue was never squarely presented to us in the first place, I think it still fails. So that's my view as to denying the motion for reconsideration and the relief it seeks. But I'd like to hear from both of you.
My thought, if I might, Mr. Chairman, is that we probably should move on the motion to reconsideration and then separately move on the standing issue, just to keep the record clear and to see them as separate. I know they're kind of intertwined. And my thought is, I agree with you regarding reconsideration, that I would dismiss that motion. And on standing, I would move to deny the standing issue before us. I think Two Farms has proven that they are in good standing with the SDAT, regardless of how we look at Pikesville hospitality. They are clearly a party in the case. So I would move on those two kind of separately. I don't know if that's what maybe you were saying, and I maybe didn't get it, but and then move on the merits of the limited development plan. That would be my thoughts, Mr. Chairman.
Thank you.
I agree with both of you as well. I would deny the motion for reconsideration and also deny the standing issue. Two Farms obviously is in good standing, and they are the developer of record. So I'm with both of you.
Yeah, perhaps I garbled my rationale because I'm not as on my game trying to parse out how this is being presented as I was with the numerous other and various motions that we've addressed. Mr. Nelson's filing is appellant's post-hearing memorandum and request for reconsideration of the board's ruling that appellant's arguments regarding CB-2318 and the planned drive-in cluster issue are time barred. So to the extent, let me clarify, to the extent what he's asking on the reconsideration is just to again revisit that issue of whether that bill is an illegal special law, then again, it's untimely and it's just already been determined a number of times. To the extent he is saying that an additional reason is the standing, and that's packaged within the motion for reconsideration for the reasons we've already discussed, that's substantively, again, denied if substance needs to be reached beyond procedure. Are you guys agreeing with how I know we agree on the outcome, but am I addressing properly how it's being presented?
I believe you are.
Okay.
I feel the same way.
Mr. Lauer?
I agree.
Okay, that's still separate and apart from whether or not the developer has met the requirements for the LEDP. These are
Correct.
These are procedural issues being raised and addressed. Okay.
I think, Mr. Chairman, that we ought to consider and vote or decide, and it seems like we have, on standing and reconsideration, and then on the merits, basically. So I see it as three separate votes, if you will, or just to clarify for the record, I think.
Okay, but within the argument of Mr. Nelson's combined motion, he says at argument 1, the board should reverse the approval of the LEDP because Pikesville Hospitality LLC lacks standing to apply for the approval of the development plan. The second argument is the board should reconsider its ruling that the planning director's approval letter in November 28 was a final appealable order because the Supreme Court of Maryland subsequently decided Town of Upper Marlboro versus Prince George's County Council, which makes clear that the planning director's approval letter in November 2018 was not a final appealable order. And then his conclusion is the relief he requests is that the board disapprove the LEDP or alternatively reconsider its ruling that the planning director's approval letter in November 2018 was a final appealable order and reconvene an evidentiary hearing. So specifically as to the request for relief that we reconsider our ruling that the planning director's approval letter in November 2018 was a final appealable order and reconvene an evidentiary hearing. I am saying that the board should deny that reconsideration. It's untimely, and we've addressed this several times, and cases need to proceed in the course that the statutes or the codes provide. And we're here today to determine whether the LEDP meets the criteria, for the approval. So again, I'm struggling to articulate what I think Mr. Nelson is raising and what we need to address. Had he not thrown in another motion for reconsideration, we were simply here basically on what almost amounts to an unopposed LEDP because he didn't advance a case. He was intending to have it rely on the argument and exhibits for the illegal special law, but then he did put in, which we'll get to in a second, stipulations of testimony that don't overcome the requirement. So again, what I think is clear is his motion to reconsider this board's prior rulings basically on 2 occasions. We in November determined that it wasn't before us, and then we confirmed at the last hearing our prior ruling and what it meant in November. Now he's asking us again to do that, and we're concluding as a board that we're denying the motion for reconsideration because it's untimely, it's beyond the 30 days. And frankly, that's really all we need to do. Secondly, turning to the substance, wherever this standing issue fits in, we are denying any relief to Mr. Nelson on this, what I believe to be untimely raised argument, but to the extent standing can be raised at any time, it doesn't affect the status of Two Farms Inc. as the applicant. And so for that reason, Mr. Nelson's not entitled to any relief requested there. Do we agree on that? Okay, so then I think then we can turn to the substance or the remaining appeal. whether the LEDP complies with all applicable regulations. Is that where you gentlemen believe we are?
Yes, and I agree
Okay.
completely.
Yes.
Okay, sorry for getting us here on a tortured path, but we're here. And for the reasons I've sort of hinted at, I believe the developer has met the requirements. It's been reviewed by representatives of the various Baltimore County agencies for compliance with the regulations that those agencies oversee. That's BCC 32-4 226B. In this case, the LEDP has already been approved by the county agencies prior to being appealed to the board. We had to hold a de novo review to determine whether it complies with the development regulations. We had a hearing to that effect. We had testimony from various agency representatives and an expert engineer from the developer. We had certain, I guess, agreed upon stipulations. Mr. Nelson volunteered to submit written statements from his witnesses in lieu of having them testify live. Counsel for the developer, along with Mr. Nelson, were able to reach agreement to stipulate some of those. The ones that were not were presented otherwise. And in my view, weighing the evidence presented, I'm convinced that the LEDP does comply with the development regulations, Section 32, Title 4, and applicable policies, rules, and regulations. And so it must be approved. And that's BCC 32-4-229B1. I find that there was substantial evidence to support the developer's LEDP plan in compliance with those regulations. I don't think it's necessary to go through all of the details of that, but we're here for deliberation. That's where I am initially. I don't think that Mr. Nelson's client identified any issue that would prevent approval of the LEDP, any issue that was before us. Stipulations did not provide any basis for denial. And to wrap it back in here, the developer, Two Farms, the applicant, is in good standing with SDAT. And so I would approve the LEDP that's been submitted. I believe it was marked in evidence, and we can attach that to our written opinion and order. That's where I am. Where are you, gentlemen?
I agree with you, Mr. Chair. The testimony was clear that the county agencies were represented. The testimony by Mr. Warfield, the expert testimony, buttressed the development plan. And according pursuant to 32-4-229B1, hearing officer, which would be us, shall grant approval of the development plan that complies with the development regulations and applicable policies, rules, and regulations adopted in accordance with Article 3, Title 7 of the Code, provided that the final approval of the plan shall be subject to all appropriate standards, rules, regulations, conditions, and safeguards set forth therein. So that's where we are. I would approve it.
And Mr. Lauer?
I agree also. I don't have anything further to add. I think you both have summarized where we are. I would approve the LEDP.
And that's all we're here to do. We're not here to give our opinions on any, our personal opinions on any of this. We have to apply the facts presented to the law and weigh the evidence and reach a determination. And that's what we've done here. So I believe that concludes our business on this matter. Does anyone have anything further that they think we need to discuss here?
I don't.
I don't believe, the only question, well, not a question, but this looks like we have to have our decision issued within 15 days. Is that correct?
I'd have to have Ms. Cannington pop back on to confirm that. Ms. Cannington, are you still on the Zoom with us?